I want to thank everyone who has joined me here this afternoon. This morning, Henry Schulke, who is the independent counsel that was retained by Judge Emmett Sullivan to review the allegations of misconduct by the Justice Department team that prosecuted the late Senator Ted Stevens. The report was released this morning. This report was completed last November, but the release was delayed until today so that comments and objections of the Justice Department prosecutors that were named in that report could be heard. That report is about I think it's exactly 514 pages. People are still going through it at this time, but I think it is exceptionally important that that full report was made public so that we could all learn of the injustices that came about from that proceeding. Last November, when Judge Sullivan announced the completion of the report, he offered a little bit of a preview, and he said that the prosecution of Senator Stevens was, quote, permeated by the systematic concealment of significant exculpatory evidence which would have independently corroborated his defense and his testimony and seriously damaged the testimony and credibility of the government's key witnesses. At least some of the concealment was willful and intentional and related to the issues raised by the defense during the course of the Stevens trial. Those were the words of Judge Sullivan. The Justice Department's prosecution of Senator Ted Stevens while he was seeking re-election presented one of the most sensitive situations that could ever have faced a federal prosecutor. The Justice Department, as we know, has a duty to meticulously guard the constitutional rights of every defendant. The Justice Department breached this duty. They sat idly by while its prosecutors did all that they could to obtain a conviction with disregard for its constitutional obligations to ensure that the defendant received a fair trial. Instead of justice being blind, in this case, justice was blindly ignored. On April 29th of 2009, Judge Sullivan described in a letter how the Stevens verdict had unraveled, and he said, the Brady violations, which were revealed for the first time 5 months after the verdict, came to light only after an FBI agent filed a complaint alleging prosecutorial and other law enforcement misconduct. Then a new Attorney General took office, a new prosecutorial team was appointed to respond to the defendant's pretrial motions. Just this morning, I had an opportunity to ask Director Mueller about the role of that FBI agent who filed that complaint. I do hope that that individual has been appropriately recognized. Judge Sullivan asked in the Ninth Circuit, Judge Richard Tolman, to codify the Brady rule. The Justice Department aggressively opposed Judge Sullivan's proposal. The advisory committee then abandoned its efforts to consider reforms to the Brady rule. I think that the advisory committee, which is composed of judges, prosecutors, and defense lawyers, this is the place, this is the ideal forum to formulate changes to the Brady rule, but that call was ignored. So now it's incumbent on us here in Congress to ensure that justice is done out of respect for our friend, Senator Stevens, and for the sake of the constitutional system. This afternoon, I am introducing with Senator Hutchinson, who is with me, the Fairness in Disclosure of Evidence Act of 2012. We are joined in this effort by Senators Inouye, Senator Begich, Senator Akaka, Senator Hutchinson, as I've just mentioned. Our effort is endorsed by many of those behind me here, by the American Bar Association, the American Civil Liberties Union, the U.S. Chamber of Commerce. It's been assisted by the National Association of Criminal Defense Lawyers and the Constitution Project. Simply stated, what our legislation does is calls upon the federal prosecutors to create a national standard for the disclosure of evidence that is favorable to the defendant, to disclose it as early as possible in the process, and to be aware that this is not an optional duty. Right now, in this country, there are 97 different standards that are used when it comes to the Brady rule. Moreover, the law makes clear that failure to abide by Brady obligations is a serious breach of the government's responsibilities, and it gives judges a broad range of remedies to address the Brady violations. Now, while the injustices that were done to Senator Stevens may have provided the impetus for the focus on this important issue, this bill is not about seeking vindication for Ted. It's about learning the vital lessons from the Justice Department's failure of his prosecution and making our criminal justice system work the way that our Constitution envisioned that it would. I want to thank my Senate colleagues who are standing with me today. I'll ask Senator Hutchinson to make some comments, and then Carolyn Lamb, friend of mine, president of the American Bar Association, during the 2009-2010 period, will address us. Robert Carey, who served with Brennan Sullivan on the Stevens defense team. We're also joined by Matt Webb, who is the senior vice president of the U.S. Chamber of Commerce. Michael McLeod Ball, who is chief of staff of the American Civil Liberties Union here in their Washington office, and Norma Reimer, who is the executive director of the National Association of Criminal Defense Lawyers. So with that, Senator Hutchinson.
Well, I want to thank Lisa Murkowski for leading the effort to correct what is clearly an ambiguous part of the law, which in the case of Senator Stevens was exploited. Ted Stevens was such a friend to me and someone who welcomed me into the Senate and was so helpful all along the way in my career. He also was a hero in World War II and was devoted to not only Alaska and America, but to the military of our country. It is sad to so many of us who knew him and in whose lives he was a part, that his legacy was marred by the actions of overzealous attorneys engaged in prosecutorial misconduct. The report that has been released today, and I haven't been able to see it in full, but have just been told that it is a stunning report that Judge Sullivan ordered to be done. The report states that the investigation and prosecution of Senator Stevens was permeated by the systematic concealment of significant exculpatory evidence. Judge Sullivan has even stated after reviewing the report that he had never seen mishandling and misconduct like what had happened in this case. When these facts came to light, the Attorney General did dismiss the case, which was on appeal. It is dismissed, but when I asked the questions of the Attorney General this week about where those people were, he said he thought they were still in the Justice Department, and in fact, at least some of them are still in the prosecutorial role. Senator Murkowski's bill, which I am co-sponsoring along with a number of Democrats as well as Republicans, does give clarity to an area of the law that almost invites the type of behavior that plagued this case. The Fairness and Disclosure of Evidence Act that Senator Murkowski is leading requires prosecutors to disclose all materials that reasonably appear to be favorable to the defendant and all information, data, documents, evidence, or objects regardless of their admissibility in court. And it specifies that disclosure must be in a timely fashion. I think it is very important that our public integrity unit of the Department of Justice be seen to be fair and supportive of our system of justice. And most certainly the misconduct in this case, I hope, results in the people who were found to have not acted fairly would no longer be in the Justice Department at all. I think that taints the Justice Department. And the Attorney General is going to have to report to the committee that is the oversight of the Justice Department what his handling of these cases will be after the report that has come to light today is digested by the Justice Department. And it is my hope that no one in public office or private life will ever have to endure what what Ted Stevens did and his family, and I'm only sorry that he died before he could see the results of this investigation. Thank you.
Thank you. On behalf of the American Bar Association, we applaud and support the efforts of Senator Murkowski and this legislation. It ensures for all defendants the guarantees in the Constitution for the Fifth Amendment due process guarantees and for effective assistance of counsel in the Sixth Amendment. It ensures a fairness and consistency in the implementation of those guarantees for all defendants. And it assures that prosecutors, in fact, don't just act to get a conviction, but act with equal justice for all, the admonition above the door of the Supreme Court. Thank you so much, Senators, for doing this. It's really fundamental for all in the United States.
My name is Rob Carey. I was one of Senator Stevens' lawyers. No amount of reform can guarantee that prosecutors will not lie and cheat as they did in his case. But this legislation today would go a long way towards making it much less likely that it happens in the future. Senator Stevens said that on the day his case was dismissed, that when the dust settled, he wanted to devote his efforts to ensuring that there were reforms to make it far less likely that what happened to him happened to others. He was waiting for this report today, and tragically, he did not live to see this report. But we're going to continue to fight for him, and we very much appreciate what the senators have done, Senator Murkowski, Senator Hutchinson, and others, to introduce this legislation, and it will make it less likely in the future, if passed, that prosecutors do not abuse their power as they did against Ted Stevens.
First, I want to thank the senators for introducing this very important piece of legislation. It's a tremendous step, I think, for American justice. From the standpoint of the nation's criminal defense bar, this is not about bad prosecutors. This is not about a few bad apples. That's part of the human condition, and no law will ever really prevent that. This is about the good and conscientious prosecutors in this country, those who understand that fairness requires that when there is information helpful to an accused person, it should be turned over, and it should be turned over promptly and properly. The law gives clear guidance and sets a standard and a benchmark for all honorable prosecutors to follow. It will establish, we believe, a culture of fairness. A criminal prosecution is the single most awesome use of government power short of warfare. It is not a game, it is not a hunt, it is not sport. It is about fairness and justice, and this law will make fairness the law of the land. Thank you, Senator.
My name is Michael McLeod-Ball. I'm the Legislative Chief of Staff for the American Civil Liberties Union. We thank you, Senator Murkowski, for introducing this important piece of legislation, and we also thank the other original co-sponsors, Senator Hutchinson and others, who have signed on to this important benchmark. We think this bill supports the principle that justice demands and depends upon fairness. The Brady rule, which has been in place since 1963, prosecutors have a duty to disclose exculpatory evidence to defendants, but sometimes, as we know, that doesn't happen. So this bill is intended to help ensure that our criminal courts mete out justice and not merely convictions. To paraphrase Attorney General Holder's comments after the dismissal of Senator Stevens' case, a prosecutor's job is not to convict people or to win cases, it's to do justice in every case, to do the right thing. Having led the Alaska affiliate of the ACLU for several years, I'm aware of the reverence with which the late Senator Stevens is held by the people of that state. And the people of Alaska have a great respect for the idea that government ought to act fairly and not abuse its power in dealing with individuals, whether in administrative transactions or in criminal prosecutions. The abusive process suffered by Senator Stevens was profound. Federal Judge Emmett Sullivan said that prosecutors engaged in this systematic concealment of exculpatory evidence, as has been mentioned before, and it's a shame that such a man as Senator Stevens had to go through that ordeal. But it's just as much a tragedy that an untold number of others who have also gone through such abuse at the hands of prosecutors were hell-bent on achieving high prosecution rates. Playing games with the system, not doing the right thing, is too often the rule and not the exception. So consider Edgar Rivas, for example, convicted on drug charges in 2003 after the government withheld evidence putting drugs in another person's hands, and then compounded its rule violation by groundlessly claiming an exception to the disclosure rule. These and hundreds, perhaps thousands of other stories can be told. And so it's not just Senator Stevens who has suffered this profound abuse, but many, many others. And this legislation is designed to get at that abuse. Senator Stevens told the court that he wanted to make sure that no one else would be victimized by the prosecutorial misconduct visited upon him. It's no longer enough for the court-issued Brady rule to exist. Legislation to operationalize that rule and to provide consequences for those who would choose to violate the spirit or the letter of that rule is needed. This is an issue that knows no party and no ideology. This is an issue that is a true justice for the American goal, and we are proud to stand behind Senator Murkowski and her colleagues and in support of the Fairness and Disclosure of Evidence Act. Thank you very much.
Any questions? We've got another vote coming up here, so we're unfortunately going to have to keep it relatively brief, but we're happy to field a couple. My office, we've been working on this for many, many months, working with the National Criminal Lawyers, National Association of Criminal Defense Lawyers for a long period of time, just in terms of drafting the legislation. The coalition that you see behind me of organizations that agree that it is necessary that we give some parameters with the Brady rule in order to ensure that justice is fair and evenly applied here. That has come together in the more recent weeks, but this is an effort that has been underway for a considerable period of time. Well, I will speak to it, and I will also ask my colleagues behind to join as well. But part of what we're dealing with right now is a matter of interpretation amongst the prosecutors to determine what is reasonably material, and recognizing that there's no real priority in terms of the timing. If that information is delivered in compliance with the Brady rule, but it's delivered too late to make a difference, then how have we worked together to achieve a level of justice? So what we try to do with this law is to give some better parameters. Again, I mentioned in my comments, right now, there's differing interpretations all over the nation, 97 different interpretations as to what it means when we're talking about reasonable timeliness and reasonably material to the case. So again, trying to put in place a standard that is well understood. If you'll recall the comments that came from the judge, he indicated that the reason that they were not going to pursue charges against the prosecutors is because the court had not directed them to follow the law. Now, that to me was pretty stunning to see a statement such as that. There will no longer be have to be a direct order from the court. It will be part of the law. And I don't know if anyone would care to comment in terms of the reasonableness aspect of it.
I would just say that this it reduces the discretion on the part of the prosecutors. You know, if you are obliged to turn over exculpatory evidence, you get to make a decision about what's exculpatory and what's not. And a lot of the cases that you see, there is an excuse offered by prosecutors that the evidence, they didn't think it was exculpatory. And so if you take away some of that discretion and impose, as the senator said, a consistent standard, across the country, I think you at least cut down on the number of abuses. If you think about whether something is material to a case, well, if it's immaterial, what does it matter if you turn it over? But if it is material, it's got to be turned over. So the default ought to be to turning over the evidence.
This law would require that it be turned over as soon as it becomes known to the prosecutor and without delay. And it would impose a range of sanctions if there is delay and it comes to light at a later point. And as my colleagues have said, the big problem with the current state of the law is, and this is why I feel this is really important guidance for good prosecutors as well, is that the materiality standard that exists right now is a subjective determination that a prosecutor is making where they can conclude, well, I know how strong my case is, this really won't help the defense that much, therefore I don't have to turn it over. This law takes that away and says if it is favorable to the defense, you turn it over as soon as you learn about it. If it is well, everything except the law has, the bill has provisions in there for protective orders, if it's necessary to protect the safety of witnesses, for sealed submissions to the court. If it involves national security, the SEPA provisions would take precedence over this. So it's a very measured piece. It's a very measured piece of legislation, but it does address this problem of multiple standards, as the senator said, throughout the various districts.
And I'd note on the consistency and fairness point, the ABA's criminal justice section, which is equally balanced with prosecutors and defense lawyers, developed criminal justice standards that were passed by our House of Delegates. We've urged the Justice Department to implement a consistent policy nationwide. They have not done so. This bill does so.
We're going to have to call it because I'm going to have to go upstairs and vote, but thank you.